Okay. And very good morning once again. We have done almost 3 introductory sessions on intellectual property law and then specifically on patents, exploring some very crucial section on patents from the Patents Act 1970. So today we will see how a patent filing process happens, and in general, without referring to the sections as such, strictly to the sections as such, I will just go and understand by the procedure of filing a patent application till getting it granted without having any diversion in the track in general course. Okay, there can be so many diversions in the track and the procedure may get complex, but without having such diversions, how can we ensure that we don't have such diversions and your patent examination process goes really smooth? And for that, we will see what are the timelines, and to have a smooth patent examination, or in other words, we call it as patent prosecution process, it is very important that you draft your patent specification properly, taking care of what are the possible objections that may come in future. So if such explanation and justifications are already provided in your patent specification, taking into consideration such objections in future by the patent office or by any other third party, then it is almost likely that your patent examination process goes very smooth without any diversion from the general course, and it is quicker as well. Okay, so having said this, we have already seen how to draft a provisional patent specification. If not, we have seen how to draft a provisional patent specification. We have seen what should be the contents of a provisional patent specification and what should be the contents of a complete specification. Okay, so if we have to draft a patent properly, then we should definitely be careful and ensure that the various contents that we have discussed in our previous sessions on provisional patent specification and complete patent specification, they are properly incorporated in your patent drafts. Okay, so now we will see, after your patent draft is ready, what to do with that and how to go ahead with it. Okay, so let us assume that we have filed our provisional patent application on 1st of January 2020. Okay, and yes, it is always better that in your provisional patent specification you give considerable experiments. Okay, if not fullest amount of the experiment, but you give considerable experiments substantially to prove that, or to have an idea that all the required experimentation, minimum required experimentation is there in your patent application. Okay, so don't file any patent application with a provisional patent specification wherein you have failed to give proper experimentation. You must give experimentation. You must give experimentation that at least proves your idea. Okay, you may elaborate on it in due course. You may give the comparative experiments in due course, but at least the basic experiments must be given in the provisional patent specification. And that's why I have written here, you file a provisional patent application with considerable experiments and disclosing possibilities in past tense. Okay, and then from filing the date of provisional patent specification, within 12 months from provisional patent specification, you have to file your complete specification. Okay, now all of you may note down. I will tell what are the forms required to file with the patent office while you file a provisional patent application. Okay, fine. So while you file a provisional patent specification, there are minimum 3 forms required for provisional patent specification. Okay, write at your end. Form number 1, form number 2 and form number 26. Form number 1, form number 2 and form number 26. Now what is form number 1? Form number 1 is the application for patent application. Application for obtaining your patent. That is in form number 1, which is a mere clerical form wherein you give the name of the applicant and name of the inventors. Now applicant are different from inventors. Okay, applicant possesses and owns the patent application or the rights coming therefrom. But inventors are the persons who has invented it. So what is the difference between inventors and the applicants? Inventors are those who are natural persons, human individuals, but applicants can maybe your scientific technical institution or educational institution. Applicant can be you also, if it is permitted as per your policy, organizational policy. Applicant can be companies, applicant can be partnership firms, applicant can be trusts, applicant can be human natural persons also. Okay, so applicants are those who owns the right to that invention, and inventors are those who own that invention. Okay, there is a transfer process which is required to be established, saying that the inventors of the invention has given the right, title and interest. Inventors of the invention has given all right, title and interest to the applicant. Okay, and this transfer document is called as assignment deed. Assignment deed. So apart from the forms that I have just said, form number 1, form number 2 and form number 26, apart from these 2 forms, while filing a provisional patent application, you also have to give a assignment deed. In those cases where the assignee, the applicant is different from the inventors. If they are same, then it is not required. If I have filed a patent application on my name and I have only invented it, meaning thereby I am the inventor and I am also the applicant, in those cases assignment deed is not required. Okay, so please take a note of it at your ends For filing the patent application, you need Form 1, Form 2 and Form number 26 plus an assignment deed. These are the minimal documents which are required to file a patent application, and these form numbers has to be there in your answer sheet. Okay, use these form numbers in your answers as much as possible depending upon what the question is. Whenever there is an opportunity to write and complete your answer through these form numbers as much as possible, don't forget to incorporate them in your answers. So any question regarding provisional patent application, please don't forget to include these form numbers: Form 1, Form 2, Form 26, Form 1, Form 2, Form 26 plus assignment deed. Okay. Someone has gotten doubt, trying to ask something.
Assignment deed, sir.
Yeah, please tell me.
For assignment deed, we have to file Form 6, sir.
For
assignment, we have to file Form 6.
No, not required. There is no form for assignment at all in Patents Act, or in the Patents Rules 2003 or in the Patents Act 1970. There is no form prescribed. So assignment deed is a separate document that you have to draft and take the signatures of the inventors and the applicants, and then you file it separately. You have to attach it separately. Alright, so just remember the form numbers right now. Your job, all of you people who are interested, your job is to see the corresponding section numbers and the rule numbers written on those forms. If you don't know how to see those forms, the online format of the forms, please go and refer my first session on the patent agent exam in my YouTube channel. So there you will find how to access the form numbers or how to access the forms. Okay, I will show you also in due course, but still, till we meet again, before we meet again, I would like to hear from all of you what are the section numbers and rule numbers associated or related to those three particular forms: Form 1, Form 2 and Form number 26. They will be mentioned, the appropriate section numbers will be mentioned in the form itself. Appropriate rule numbers will be mentioned in the form itself. So please go and try to find out what are the form numbers for section number for Form 1, Form 2 and Form 26. And please be known, there is no assignment, there is no form at all prescribed under the Patents Act 1970 and the Patents Rules 2003, the Patents Act 1978, the Patents Act 1978 and the Patents Act and the Patents Rules 2003. There is no form prescribed for assignment deed, but the assignment deed is a very crucial component in filing your patent application so that your patent application is in order.
Sir, okay. Proof of right and
yes.
Sorry for the disturbance.
Yeah, please tell me.
Proof of right and assignment deed both are same or different?
Same, both are same. That is called as proof of right. I was just going to tell that. Assignment deed is also termed as proof of right. Okay, so these are the forms which are required to file your provisional patent application. Now, as I was telling, Form 1 is a mere clerical form, but it includes all the information about the inventor, name, nationality and address. Name, address, nationality of all the inventors, name, address, nationality of all the applicants. Okay, then what kind of patent application it is. There can be so many kind of patent applications, but I am talking about ordinary patent applications. Okay, there can be divisional patent applications, there can be patent of addition, there can be national phase entry of a patent application from a patent file under the Patent Cooperation Treaty earlier. Okay, so among these different kinds of the patent application, you have to select what kind of patent application you are filing. So I am assuming and I am going by the ordinary course of action in which you file a basic first Indian patent application in India, which is called as an ordinary application. Okay, so you have to disclose that in the form 1, plus there are other declarations by all the inventors in form 1 as well, that you are the inventors to that particular invention for which a patent application is being filed. Followed by there are some additional declarations in relation to the National Biodiversity Authority, that you will obtain the approval of National Biodiversity Authority, NBA we say, under the Biological Diversity Act 2002, without which you cannot get a patent granted if the patent involves and concerns any biological material isolated from or obtained from India. Okay, biological material or any sample from any plant resource or anything that is taken from the natural flora and fauna of our country. In those cases, you have to obtain prior approval under the National Biodiversity Authority, and then only you will get the patent granted. But be known that even if you have not obtained the approval yet, that does not stop you, or that does not it is not like you will not be allowed to file your patent application. You can still make your patent application, provided that during the course of your patent application you will obtain during the course of your patent application, as long as it has not been granted and the examination is undergone, by that time you will obtain the you will obtain the approval from the National Biodiversity and submit it with the patent office. So before grant of the patent, you are required to submit the approval of National Biodiversity Authority, and that particular thing you have to declare in your particular form of patent application, which is in form 1. So this is about the contents and the basic contents and the subject matter of form 1. In form 1, you do not mention anything about your invention except title. Title you have to write in form 1. Okay. Then form 2. Form 2 is exactly the patent specification. The entire patent specification, the contents of provisional patent specification, complete specification, whatever we have discussed, all of these are in form 2. This itself is a form which is prescribed under the Patents Act 1970 and under the Patents Rules 2003. Under the Patents Act 1970 and under the Patents Rules 2003. Okay. So form 2 we have already discussed in detail in our prior sessions. So form 1 is the application for patent application. Form 2 is your provisional patent specification or complete specification, either of the two. You have to specify in form 2 what kind of form 2 it is. Is it provisional patent application, or is it provisional specification or complete specification? So if you are making a provisional patent application, you have to write on form 2 that it is provisional patent specification. Okay. Then when you are filing the complete specification within 1 year, you have to write You have to write on your patent application in form number 2 that your filing, your particular patent specification is complete patent specification. You have to write it. You have to mention it. If you don't mention whether it is provisional specification or complete specification in form 2, your form 2 is incomplete, your form 2 is wrong under the eyes of law and may not be entertained at all. So in your exam, don't forget to write these particular details. Okay, form 1, form 2, and then I said form number 26. Now form number 26 is the authorization given to a patent agent. Form number 26 is the authorization given to a patent agent to file that patent application representing the applicant. Form number 26 is the authorization given to the patent agent to file this particular patent application on behalf of and representing the applicant. Under practical circumstances, the applicant will be unaware of which particular forms to file, how to draft a patent specification, and therefore you are giving this exam to be a patent agent, and once you are patent agents, you will get the authority and capacity to represent others and file others patent applications on their behalf, and for that you need a legal authority to do so. Therefore you act as their agents to represent them in front of the patent office so that their patent application is made correctly and following all legal requirements in front of the patent office. So that is also called as power of attorney or power of authorization. So the form numbers goes in making a provisional patent specifications are form number 1, form number 2, form number 26, and proof of right, or in other words assignment deed. And I will give you templates of all of this. If form 1, 2 and 5, form 1 to 26, you will get it in the website itself, in the IP India website itself, but assignment deed, if you need formats, I will definitely share with you. Okay, there may be a question in the patent agent exam wherein only an assignment deed is asked. Okay, so I will share a draft template of assignment deed wherein you understand the subject matter of the assignment deed. You may not write it properly in legal terms without seeing that in the exam, but if you remember the crucial points, what are the particular aspects which needs to be incorporated in an assignment deed, if you remember them, you can write it in your own manner in the patent agent exam. Okay, like who is assigning, what is being assigned, what can the assigner do, on what premise the assigner has got the right to file the patent application, what has the assigner given to the assignees. Okay, sorry, I was telling just the opposite. What has the assignee given to the assigners to get the right and file the patent application by the assignee. Okay, there has to be some consideration, like as I was telling, patent filing is a contract, even proof of right is a contract. If you have invented something as a person and then you are allowing that invention which you have invented to be filed on the name of somebody else, and that somebody else may be your educational institution, that somebody else may be your company where you are working. So in the assignment deed there should be first identification of who is the assigner, who are the assigners and who are the assignees, and then what is this assignment about, wherein you should mention the title of the invention which you are filing in your provisional patent specification. Okay, that is being assigned. And why it is being assigned? Like, what did the assignee give to the assigner to get that right from the assigner? Okay, so these are the three important points in an assignment deed, and that you can draft it in your own manner, or you can, if you can remember the template that I will be sharing, that is very good enough. Alright, so after having filed the provisional patent specification, let's come to the point wherein you have to file the complete specification. In complete specification, what are the additional forms to be filed? Can anyone say? To make your patent application complete?
Form 5, sir.
Claims.
Sorry?
Claims.
Okay, claims, very good. And I said forms. What are the additional forms?
Oh, okay.
Form 5, sir.
Correct,
Okay,
form 5. The additional form that has to be filed is form 5 to make your patent application complete. Form 1, form 2, sorry, there is one more form that needs to be filed. Anyone? Naveen?
One is the
Naveen, can you say? Or Dr. Samba, can you say? Rajeshri, can you say?
declaration form that I'm the first inventor of the
That is form 5.
form 5.
Okay,
The other one.
I'll say that. Okay, Naveen is saying form 3. Very good. Yes, form number 3. So while you make the patent application, complete patent application, you have to file 2 additional forms, form number 3 and form number 5. Form number 3 is declaration that you have not filed the patent application in any other country except India. And also, if you have filed it in any other country, inform in your declaration where else you have filed. And form 3 needs to be filed repeatedly, not only once. Form 3 needs to be filed repeatedly within 6 months of occurring some particular events in due course of this particular patent application. Okay, within each 6 months of occurring some events in the due course of this patent application process or the patent prosecution process, within each 6 months from such events occurring, then you have to file additional fresh form 3s. For example, if you have filed this patent application correspondingly the same patent application under the Patent Cooperation Treaty and made a PCT application of this patent application, then you have to file form number 3 within 6 months of filing the PCT patent application. And if the deadline of filing the PCT patent application on the basis of a provisional patent application is same, that is within 12 months of filing the provisional patent application. Now, for example, if you are filing your provisional patent application on 1st of January 2020 and you are filing your complete specification on 31st of November 2020, then in that case form 3 will be required with the declaration that you have not filed anywhere else in India and except in India on 31st November 2020. Still now you have not made any PCT patent application, but after you have filed a complete specification, your patent agent suggests, sir, you should also consider filing the patent application in under the Patent Cooperation Treaty. Now, what is Patent Cooperation Treaty and all, I will explain later. So if you and you agree to file, you agree to incur the cost of filing the PCT patent application for your own benefit, then in that case you will realize, oh, I got another 1 month additional remaining with me, so let us quickly file the PCT application within this 1 month because the deadline is ending on 31st if not 31st December 20, it is ending on 1st of January 2021. So on 15th of December 2020, you complete making your PCT patent application based upon the same provisional patent application. So in that case, Form 3 will be required to be filed within 6 months from 15th of December 2020. A fresh Form 3 has to be filed, wherein you have to say and declare, I have filed this particular patent application in PCT and also giving the PCT application number and the date on which it has been filed under the PCT. All compliances may be done, but if you have not complied with form number 3, filing form number 3, then your patent will not be granted. Even if your patent eligibility criteria are met, even if your patent examination has gone smoothly, it is ready for grant, but the patent office will not grant this patent until and unless you have updated yourself with filing all the form 3s as much as required, corresponding to this specific patent application. It is a continuous requirement, filing form 3. Generally people forget, file it once at the time of provisional, at the time of making complete specification, and then they forget. Actually some of them file in the provisional patent application also, which is not required. Okay, they should have filed it at the time of filing complete specification, which they do not do. So these kind of lacunas happen, and on these lacunas only the patent agent exam may ask questions like that. When do you require to file patent form 3? If not directly, they will say that the applicant wishes to file his patent which he has earlier filed in India, in USA or in any other country, and it is only 14 months which has passed from making his complete specification. Now please tell me, please advise your client how will you make the patent application in USA. So in order to answer that question, you have to say that under the PCT rules, under the Patent Cooperation Treaty rules, a corresponding application based upon this present patent application can be filed within 31 months from the date of provisional patent application. Now since it is only 14 months of having filed the provisional patent application, there is still time remaining of filing the patent application in USA, and the question already mentions that the applicant has filed PCT application. Only if PCT application has been filed, the applicant is entitled to file the patent application in USA within the deadline of 31 months from the date of provisional patent application. So since only 14 months has passed from the deadline of filing the patent application, the applicant can file a national phase patent application in USA based upon the same patent application in India, filed in such and such date. So after you have given this answer, the crucial part everyone will forget. The crucial part is they will not mention in their answers how to comply with the Indian Patent Office after filing the patent in USA. So the compliance part with the Indian Patent Office after having filed in USA is filing form number 3 with Indian Patent Office within 6 months of filing the patent in USA. So that's what I was mentioning, that during the patent examination process there will be some events occurring, and based on such events occurring at their respective time points, from those time points you have to file fresh form 3s each and every time within 6 months of each such events. Did you get it, all of you? There is a continuous confusion with everybody, when should I file form 3? Please remember this. Questions will come based upon this particular discussion. Definitely it will come. I don't need to see the previous patent application exam papers. The answer remains the same, the question comes in various ways. The answer remains the same, the question comes in various ways. I am sure. I know. That is my experience. The patent office will only check how much do you know under practical aspects. How much do you know under practical aspects to practice patents in India. Okay? Fine. So, complete specification is filed. What happens after filing the complete specification? As I said, if you file a patent application, the patent application, even if you write a Bollywood song in your patent application, the patent office will not review at all. It is the duty and obligation of the government executed through the patent office as a representative of the government that the government will publish your patent application for sure, and that publication happens within 18 months of provisional patent application or within 6 months from filing the complete specification if you have filed the complete specification at the 12th month. It is not that within 6 months of complete specification, that is an incomplete statement. Within 6 months of complete specification is correct if and only if you mention in your statement that the complete specification was filed and on the 12th month of the making the provisional patent specification. So in the slide everything is with respect to provisional patent application. Okay, so the publication of patent application is done by the Intellectual Property Office of India in the patent journal. In the patent journal, and there will be a publication number as allotted, journal number allotted for your patent application. And in the publication, important question, what are the contents of publication? What are the contents of patent publication in India? Okay, I will try to give the answer. The question may come in different ways, I am telling you. Okay, so please try to understand what I am discussing. If you go at this point of time, if you go and search in the books, you will not get the answers. So listen to me, make your note, you can easily answer, and that answer will fetch you considerable marks, substantial marks, if not full marks. Okay, contents of patent publication. Everybody will say the entire patent will be published. No, in India the entire patent is not published. Only the title and abstract and the details of the inventors and the details of the applicant is published. Those are the information which is published by the patent office in India. But unlike in other patent offices, the entire patents are being published. But in India, in general, I should not make specific statement. In general, I am telling a patent application filed, suppose in US, then the entire patent application as filed in US will be published in the publication at 18 months. But in India, only the name of the inventor, the name of the applicant, the name, address, nationalities of the inventor and the applicants, the title of the invention and the abstract of the invention is published. Nothing related more than that in the published journal. But in practical terms, the entire patent application as published is visible after 18 months because the patent office provides the documents which is available freely and online to be accessed by any public at any time after 18 months of the patent the provisional filing. Before 18 months you will not get, but after 18 months the official publication will not contain the entire subject matter or the entire provisional or complete specification as filed with the patent office, but only the abstract and the title of the patent plus the details of form 1, nothing more than that. But the patent application as filed may be accessed viewing it from the application status of the IP India website, and you can know what exactly is the subject matter in detail of the provisional patent specification or the complete patent specification as filed. So any third party can see and check your subject matter of the invention accessing the documents filed under the patent application. But under the patent publication officially, those documents will not be available. The publication document will not make available the complete details of the provisional and the patent complete specification. Publication will be of the latest filed complete specification. Yes, Rajeshwari, good question. Why the Act says it can be obtained by paying fee? It was, everything has become online right now. I was coming to this, Rajeshwari, good question. Everything has become online now, so for the purpose of fulfilling the social contract, that is the obligation of the government, it has made available for the public at large to access all documents filed for a patent application from the IP India website, which was not possible at the time the Patents Act 1970 started, or the Patents in brackets Amendment bracket closed Act, 2000, Patents Amendment Act 2000, amendment should be under brackets. From when the Patents Amendment Act 2005 started or was commenced, from those times there was no such online system wherein anybody can access the documents and see what is the patent application about. For those previous times, earlier times, if anyone wanted to see what is it regarding the patent application in detail, at that time you have to pay and obtain the complete details of the patent application by paying additional fees to the government. See, filing patents are nothing but contributing to the national economic resource. I mean, it's a revenue generation of the government. Okay, so for you want to file a patent application, you are generating revenue for the government by paying official fees. Similarly, it is at the option of the government that it has kept mandatory that if anyone wants to see the complete details of the patent application, he has to pay an additional fee and see the complete details of the patent application, the complete specification of the patent application. But now this has become obsolete because government has decided to make it freely available to all sections of the public, either from India or outside, if you know how to access those documents. Got it, Rajeshri? Am I clear?
Yes.
Okay, fine. Then what happens after publication of the patent application? You have, if you want the patent to be granted, you have to. Now, can anybody tell, before I go to request for patent examination, can anybody tell what is the form of publication of patent application?
Request for publication.
Form for publication of patent application.
9.
9, sir.
Who said 9? Rajeshri? Rajeshri or Srilakshmi?
Srilakshmi, sir.
Okay. The form 9 is for publication of patent application. Rajeshri, no. Naveen says form 9. The answer is wrong. There is no form required for publication of patent application. Okay, there is no form required for publication of patent application. Form 9 is the form applicable when you want your patent application to be published before 18 months. At that time you file form 9. Okay.
Just a small question, sir.
Sorry.
I have a question.
Yes.
Why this 18 months, sir?
It's a policy decision. I don't know. Maybe it is written in TRIPS
Okay.
agreement.
Okay. Means
I
because
don't know
as
in
such they
detail.
are
I don't remember in detail the TRIPS agreement, but I believe it is written in the TRIPS agreement, and it
okay.
is
Thank
common
you.
in every country.
Okay. Thank you, sir.
Okay, publication of patent application. There is no form mandatorily required for getting a patent application published. But yes, when you want your patent to be published earlier than this 18 months period, in those cases you file form 9. But again, keep it to your mind. Be very careful. There in form 9, don't write request for early publication. If you write in your form 9 request for early publication, then that form 9 becomes wrong answer. Because if you see form 9, there is nothing called as request for early publication. It is request for publication only. Okay, in form 9 is request for publication only, but that is not a mandatory form to be filed. If you want your patent to be published before 18 months, then only you can file form 9. And why would you require this form 9 to be filed? Meaning, why would you require your patent application to be published before this 18 months period? It is because your patent will not be granted until and unless it is published, and there is at least 6 months of publication period. There is at least 6 months of publication period from the date of publication. Now, why this publication is necessary for a patent to be granted? Publication of patent is necessary for giving opportunity of public at large to know and oppose your patent application if they feel so that your patent application is not new, or your patent application does not comply with all the requirements under this act to be granted a patent. There are several grounds of patent opposition given in section number 25. There can be pre-grant oppositions under section 25 subsection 1. There can be post-grant oppositions even after the patent is granted. Within 1 year from the grant of the patent, still then the patent can be opposed under section 25 subsection 2. But opposition is not possible until and unless people are being known. People are not being communicated of your patent application having published, having applied for by you. For that reason, the patent application is published. And if you want your patent to be granted sooner, you may opt for request for expedited examination. Or earlier, when request for expedited examination was not available, you might have not filed complete specification and provisional patent specification separately. To get an early grant, you might have filed both the specifications together, stating at complete specification, and on the date of complete specification only, you might that is making the initial application of that provisional application only. On that date itself, you don't file provisional patent application, but you make it directly a complete patent specification. And with the complete patent specification, you file form 1, form 2, form 3, form 5. You file everything, and also file form 9. And also file this particular request for examination, which I will say right now. Request for patent examination. You file everything on the same date. By that way, you got eligible to get a grant of the patent comparatively earlier than general course. Apart from making these events happening separately at different time intervals, at 12 months, at 18 months, within 48 months, you do all of them together. Okay, in those cases, see, if you file the complete specification at once, initially only, still in general course, that patent will be published at 18 months of that initial filing. Even if you have made company specification directly, the patent office does not understand that you have made company specification directly. It will go by its own way. So, in the sections it is written of making the patent application, Patent application. What patent application is not given in the act. But if you go by the rules, you will come to understand the differentiation of the patent application, whether provisional application or company specification. But still, if you, for the patent publication, it is always provisional, the first initial date of patent application, which is also called as the priority date. The date of filing the provisional application is also called the priority date. Why priority date? Priority date means if you go and file this particular patent application in future in any other country, complying with all the patent filing systems under the PCT or under the other conventional agreements like Paris Convention or any local patent cooperation agreement with any other country, with India. Okay, if you follow if you are within the timeline and follow those regulations as specified in different treaties, then whenever you file them in any other country, those countries will consider having filed that patent application in that country on the same date when you file it in India, when you first file it in India. So, filing a provisional patent application is important for the purpose of generating a priority date. Once the priority date is generated, it is going to be constant and uniformly applicable all over the world, irrespective whenever you go and file the same patent in different countries subsequently. The actual filing date will not be considered the filing date in that particular other country. The filing date will be considered as the same date on which you first file it in India, that is filing date of the provisional patent specification in India. That is the relevance of priority date. Okay, so filing the patent application first initially, either company specification or provisional patent specification, you generate your priority date and the patent application will be published 18 months from the priority date. Okay, so 18 months from the priority date, if you want a patent to be granted earlier, even now if you want to do so without paying the extra fees for expedited examination, you can do so filing everything together and filing a request for publication of the patent under form 9. Okay, if you file request for publication of the patent under form 9 right on the day on which you are making the patent application, then the patent application will be published within 1 to 2 months immediately. Okay, and if you also file your request for examination, now comes the matter of discussion of request for patent examination. If you file the request for patent examination, then only the patent office will examine your patent. Otherwise, the patent will never be examined. Otherwise, the patent will never be reviewed. Got it? And what is the deadline of filing the request for patent examination? It is 48 months from provisional application. It is 48 months from provisional application. And what is the form for filing request for patent examination? Everyone, anyone or everyone?
Form 18.
18.
Yeah, everyone
Form
knows that.
18.
Form 18. Good. Now tell me the section number.
Request form section 15. No. Section 11B.
Others?
11B, sir.
Good. Great. Thank you, Dr. Samba. Great. Section 11 and rule 11B and rule number? Rule number
24B, sir.
24B. And for expedited examination,
24C, sir.
expedited examination,
Form 18A.
Yeah.
Form 18A, very nice. But rule number
24C, sir.
24C, okay, C for cap, 24C. So make a note of all this. Whenever Rajeshri, you are confusing with the point of discussion. We are not discussing revocation of patent right now. Anyways, I'll answer your question. Revocation can be done anytime. It need not be done within 1 year. You ask the question, is it possible to initiate revocation proceeding within 1 year of grant during the post-grant time? Yes, it is possible. Answer to your question is yes, it is possible. And for revocation, it need not be done within 1 year. It can extend till 20 years of the lifetime of the patent. Anytime you can revoke a patent. If you feel that the patent has been granted without compliance of the conditions under this Patents Act 1970, then any time during the lifetime of the patent, you can ask the patent office to revoke the patent which has been granted, which is completely separate proceedings under the Patents Act. Okay, form number 4. What about form number 4? Naveen asked me.
Request for extension of time, sir.
Correct. Very nice. Very nice. Great. You have gone through my earlier directions. It is apparent. It is easily understood. On certain occasions only, not all. For anything, you cannot extend the time by way of filing form 4. And for extension of time, you have to file form number 4 within the first allowance of time, applicable time allowed to you. Within that deadline, if you are not able to file the required document before the patent office, then you have to extend by filing form 4. If you have not filed form 4 within the initial amount of allowable time, then you lose the opportunity of filing form 4. And there are only some specific subject matter for which you can file form 4. You cannot extend time for all subject matters. So let us not go and confuse two different things. Okay, I am just, as I said, in general and original in ordinary course of action, keeping our patent application and the patent prosecution smooth, what are the minimum applicable events from patent filing to patent grant? So there, let us assume that we don't need to extend the time at all. We complete our duties and obligation within the time allowed to us, and we will see that what are those things. Okay, let us follow the basic timelines first. Yes, questions will come from form 4. Naveen, you are correct. From form 4 questions may come. I will discuss them later. But unless this basic timeline is understood to everyone, you will not understand what is form 4. You will not understand what is form 6. You will not understand what is form number 12. Okay. So if we have the basic, see all the other forms which are there, everything is with regards to deviation from this basic timeline. The patent office allows you to comply with the deviations if so happen through these other forms. Okay, the patent office, the lawmakers have the lawmakers recognize that it might be so that for some of the other circumstances following these general timelines is not possible. So for these reasons, they have also identified where it can be possible that these timelines has not been, or this general flow has not been complied with for different other reasons. Okay, so in those circumstances, what do we do? For those reasons, other forms has been also given under the Patents Act 1970 and the Patents Rules 2003. So to understand all other forms, you have to first understand these basic forms. Okay, so with the reference to these basic forms and these basic timelines, you will understand easily what are the importance and why the other forms or any other particular form number is required. Okay, so I have said so much on the premise of request for patent examination, but I have not dealt with the request for patent examination exactly. Let me say, within 48 months from provisional application, you have to file the request for patent examination. Okay, so it is a patenting strategy. Some of the patents in which the request for patent examination is filed at the 48th month. On the 48th month, to delay the patent examination process for some of the other strategic reasons. Okay, or you file it as early as possible, either on the very first day of filing the patent application, on the priority date, or any time in between after publication of a patent application. But the timeline will be 48 months from provisional application. Okay, be known that if you are making a provisional specification on your priority date, that means you are filing a provisional patent specification, and on the same date you also file a request for patent examination. In order to getting your patent examined as quickly as possible, you file form 18 on the day of making provisional patent specification, then the patent office will not entertain your request for patent examination. Did you understand what am I telling? For example, on the date of file on 1st January 2020, I file a provisional patent application, and on such date I also file form number 9 for request for a provisional application, and on such date I also file form number 18 for request for patent examination. In such case, the request for filing the request for examination for patent, is not going to be entertained at all, because to examine your patent, to publish your patent, you have to file complete specification. If the complete specification is not filed, the patent cannot be published, the patent cannot be examined. Okay, even if you don't remember the section numbers, corresponding section numbers, remember this particular fact. The question may come, the answer remains the same, the question may come again in various form. Okay, therefore, to getting your patent examined, you have to file the request for patent examination within 48 months of provisional application. What's next? Then, after you have filed the request for patent examination, then and only then the patent office will review the patent application and see whether your patent application complies with all these requirements: novelty, inventive step, enablement, utility, and non-patentability. Novelty, inventive step, enablement, utility, and non-patentability. Okay, and this patent examination process. So, request for patent examination was filed under section 11B. Okay, so patent examination is done under next sections, subsequent sections, section 12 and section 13. Under section 12 and section 13, the patents are being examined. The patent applications are being examined. Patents are not examined. That is a wrong statement again. Patents are never examined. Patent applications are examined. Be careful with such statements when you state in a patent agent exam. Don't say the patent will be examined. The answer will be by itself become wrong. Alright? Okay. Please give me a moment. So under section 12 and section 13 of the Patent Act 1970, under the Patents Act 1970, the patent will be examined on these particular criteria. Okay, and the examination of patent application concerns mostly on, in general, on which particular section? Can anyone say? During patent examination, let me tell you, section 21JA, inventive step. The most difficult part of overcoming the patent examination process is section 21JA. You have to establish and argue how and why does your patent application satisfies section 21JA and has an inventive step. Others are also important, but the most difficult part is this inventive step. Okay, and subsequently, even if they follow this novelty, inventive step, enablement and utility, they will still become non-patentable if they are given in section number, which section? Anyone?
Section 3, sir.
Pardon, sir.
Which one?
Pardon, sir. Can you repeat question?
Non-patentability, which particular section?
Section 3, sir.
Section number 3, correct.
Section 3.
Yes, correct. Okay, Naveen says section 3 and section 4. Naveen, please remember and please understand, I said in day before yesterday also, I think, I said section 4 is not non-patentability. Section 4 is a regulation. It may be allowed to get a patent granted under section 4, but once the approval is given by the central government. Section 4 is a secrecy direction. If it is found that the invention concerns about national security or may be useful for the country for the purpose of ensuring its national security, for the purpose of its own defense, or if it relates to atomic energy, then the patent to be granted, for the patent to be granted, that secrecy directions has to be first withdrawn and correspondingly approval from the central government needs to be obtained to examine your patent application, and thereafter the patent may be granted. So directly, if anybody asks what are the sections based upon non-patentability, don't ever say section number 4. It is only section number 3, because section number 3 categorically, specifically, explicitly mentions in its title, inventions not patentable. Inventions not patentable. Section number 4 is just a temporary block. It is just a temporary block, might be permanent for that matter under practical terms. But theoretically it is not a permanent block on patentability. Got it? Remember this, Naveen. Okay. Further, after the patent has been examined, then what happens? The patent office gives you a patent first examination report, and it will cite the reasons, it will cite different prior publications. Now, please be known that irrespective of whatever prior arts you have given in your complete specification or in your patent application, this list of prior arts is not compulsorily exhaustive in nature. They are not exhaustive in nature. That means they are not complete. The patent office is at liberty, not only the patent office, any public at large, any individual from the public at large is at liberty to cite any other prior arts which you might not have cited in your patent applications. So your claim on your patent application is always Someone's noise is coming as well. Your patent applications will be claiming that my patent application is new. My patent application is new, but it is not so according to the government always. The government will, before it gives you the specific right, the special right exclusively to you, it will ascertain with itself that it is really new. And for that matter, the patent office will cite other prior publications which you may not have cited in your patent. New prior arts. Okay? And then based upon those new prior arts, they will say that your patent does not comply with section number 2.1. Which section? For novelty?
Two L, sir.
2?
2.1L.
1J, sir.
Yes.
New
both are
invention.
correct. 2.1J and 2.1L. Both are correct. Both together. Because 2.1J says new product or process. And from 2.1J only 2.1L comes. Okay? And from 2.1L section 29 comes. We'll see what is section 29 later. Okay? So from and then inventive step section 2.1JA, enablement section number 10, utility section 2.1J, non-patentability section 3. So under all these sections, based upon the prior arts and how you have drafted your patent, if you have written a patent, it claims you are claiming like you are writing a story, then then that is again not enabled. Everything is fine, but the claims are not proper. It is not in the manner how it should be in the patent specification. Okay, so all these things will be checked, which is called for the particular purpose of claims. It is called conciseness and clarity of claims. Okay. And claims should be enabled. That means what you are claiming in one sentence should be explained in detail in your patent specification somewhere through experimental and results of those experiments. That is the meaning of enablement. So all these things will be considered by the patent office, and then the patent office will give you a first examination report which has to be responded to by the applicant within 6 months of issuance of the first examination report. Anyone can tell me where it is written that within 6 months from FER you have to define the date you have to file a response to the first examination report? Section 21. Correct. Okay. But try to identify the specific section 21 with the specific subsection number. I'll tell later on. But even if you don't remember the specific section number, within at this moment, if you just remember within 6 months you have to file the response to the examination report, that is fine. Okay, I will tell you the section number definitely, but you try to find out first. After you have filed a patent examination report, first examination report, if the patent office accepts your response, finds it to be persuasive and complete, then the patent office grants your patent and again publishes your patent application. So a patent application will be published 2 times in due course of its prosecution. Once at the time it is published, and next at the time it is granted. Okay, so there will be 2 times of publications of the same patent, and publication of the granted patent will contain the amended claims, because once you file the patent application with the initial set of claims, you might be claiming a greater scope and extent and ambit of protection. but based upon the prior arts that are cited in the patent examination report, based upon the prior art cited, you might be required to amend your claims and narrow down the restrict and extent and limit of your claims. Narrow down the extent and limit of your claims. And you might be required to sacrifice or give away some aspect or protection in the claims. So the extent of protection of your claims narrows down and accordingly gets amended, for which you claim protection, for which you want the claim to be granted by the patent office. And only those claims which are granted are published by the patent office in the granted patent publication. Okay. Now this is subject to following compliance with all the required applicable compliances. I mean, still now MBA approval was not in picture, but for the patent to be granted, by this time you should submit the letter of approval from the National Biodiversity Authority under the Biological Diversity Act 2002 before the patent office for your patent to be granted. Okay, if and only if the invention involves and contains any biological material. Fine. So after the publication of granted patent, what happens? Okay, before it gets published, what happens if the response to first examination report is not found adequate? The patent office is still not convinced with the patent examination report, with the response to the first examination report. Then the patent office will give you a hearing opportunity. Hearing under section 14. Okay. Once you have attended the hearing, and after the hearing you have to again submit your written submissions of what arguments you did in the hearing process within 15 days of the hearing. Within 15 days of the hearing, you have to file your post-hearing submissions. And then if the patent office finds it acceptable, then only it is granted again and then accordingly published. So after response to the first examination report, there can be two ways of getting the patent granted. Once directly without the hearing, other is after the hearing process. And thereafter the patent is granted after following all these things, provided if there was no pre-grant opposition. That means from the date of publication of the patent, here till this date, from this first publication till second publication, within this date, if anyone finds that irrespective of the patent examination done by the patent office, I am still of the opinion that this is not eligible to be granted a patent, this is not new, this can be easily anticipated, predicted or derived from other applicable prior arts which you have with you. But in those circumstances, you will need to oppose the patent, and only if there has been no such opposition of your patent application by any third party before your patent got granted, that is, if there is no pre-grant opposition, then this entire set of procedure applies, and this is the basic set of procedure from patent filing to patent grant. Alright. So did you understand, all of you, the patent filing to grant process?
Yes, sir.
Okay. So Please be known. Okay, let me ask you a question. What is the form to file response to first examination report? What is the form to file response to first examination report? Good, good, Rajashri. No form. Yes, no form. But I will show you practically how do we do that. Okay, I'll show you practically how do you do that in the e-filing portal. Fine. So whatever we have discussed till now, this was the basics, and not only the basic, you have already covered the 50% of the syllabus. You have already covered the 15% of the syllabus. And with this basic understanding and information on the patent agent exam, you can understand the later parts of it and take the exam conveniently. If this basic part is not clear, all the other parts of the associated syllabus of the content of the patent agent exam, particulars of the patent agent exam will be difficult to you. Will seem difficult to you. You will not have any set path. So I request all of you, all the interested examinees who have applied for the patent agent exam and who could not attend these live sessions, I request all of you to at least go by these four initial sessions which is available in my YouTube channel. Please go by them from starting to the end. Then definitely you will find the entire exam easier. And after this, I will start going into the more deeper aspects of the patent agent exam. With respect to the questions, what will be coming? From today, I will not go by the act as a textbook. Okay? I will only discuss the questions which may be coming for those to understand those deeper aspects with respect to the answers to the questions. If you want to understand and remember the answer to the questions, you have to remember and understand at least this basic procedure and the basic things that I have discussed in my initial introductory sessions. Fine. So I believe you found it useful, and thank you very much for attending and going through these sessions. For any further requirements to take this exam, I am always there for you. Please connect with me personally. You have my connection details, you have my email IDs, all of you. So please, or else please comment in the comment below for any requirements, for any further help on this patent agent exam. Thank you very much.
Sir, I have a small question. Can I?
Yeah, please.
PCT patent, where we should file, sir? Indian Patent Office or online or where?
All the applications has to
PCT.
be made online, but
Okay.
in different websites, meaning thereby in different platforms. PCT patent
Okay,
application is not made in the Indian Patent Office.
Okay.
Yes, it is made with the PCT, but in which India is concerned as the Indian Patent Office is considered as the receiving office. Okay, but you have to make it. If you want to file it physically, you have to go and visit Delhi Patent Office. But
Okay.
you have to file online. In that case, you have to file under the PCT website, PCT e-filing platform, in which the application will be considered made directly to the PCT through the Indian Patent Office.
Okay. That we should inform to Indian Patent Office. So PCT, I so and so PCT file like that.
Exactly. You have to inform again through
Okay.
some forms.
Okay.
Again through some forms in the e-filing portal of e-filing patent of
Okay.
India.
Okay. Okay. Okay.
Okay, and
So
PCT. Yeah, tell me please.
okay.
Tell me please.
So yeah, after that I want to I made a PCT. Then after 6 months I want to go to USA, but I'm not coming back. I'm not interested to file in India. I'm going to file in US only. Is it possible?
Yeah, it is possible. You did not wait for 6 months.
Okay.
You need not wait for
Okay.
6 months. Just after filing the PCT, you can file it.
Okay. So that I should again inform to our Indian Patent Office.
Yes.
Right?
Yes. How?
Okay.
How? Tell me how.
That form 20, this one, form 20, form 8, sir.
It's not form 8,
Form
section
8,
number 8, form number 3.
Oh, yeah, sorry, form number 3. Correct.
Form number 3
Form
and the
number
section
3.
number 8.
Okay.
Okay, that's what I have been discussing in this session also.
Okay, thank you, sir. Thanks a lot. It's more
Thank
useful.
you. For the live participants, please be with me. I'm just ending the YouTube session here. Okay? Thank you.
Okay.
Be with me for a moment.